Hello, this is the first in a series of lectures that I'm recording to help students who are doing the Intellectual Property module on the University of London International Programme. My name's Peter Groves and I'm a solicitor. I specialise in intellectual property law, but in addition to practising it, I've been teaching it for many years. And in particular, I've been teaching students doing this London University International course. If you've found the recorded lectures on the London University VLE for intellectual property law, then you might have noticed that I recorded them too, but that was many years ago and there have been a lot of changes since. What I'm doing is following the structure of the course as it's set out in the module guide, and the first chapter is very much an introduction. Not much has changed there, so the difference between this and the earlier recording is going to be that there's more stuff in it. And I hope the additional stuff is going to make the subject more interesting for you. I've always regarded it as an important part of my job, not just to convey to students what intellectual property law is all about, but to help them become enthusiasts for the subject. Of course, I can't claim that I always succeed in doing that, but it has worked many times, and it's very gratifying when it does. I also write a lot about intellectual property law, and I hope you'll find a lot of useful information on my intellectual property blog, which you will find at www.ipsojure.co.uk. That's also where you can find the slides that accompany this lecture. Not that this particular lecture needs much in the way of slides, but future ones will. So this is certainly not an audiobook version of the subject guide, and even if you haven't already studied copyright, you'd be able to see many reasons why I couldn't do that. What I'm trying to do is to pick out the important points from the subject guide and also to expand on them in a way that I hope will make them easier to understand. So view these lectures as an accompaniment to the subject guide, or the module guide. I'm trying to guide your study, and I'm hoping that most of your studying will take the form of reading the textbooks and the cases and the other materials that you're directed to in the subject guide. But frankly, I'm under no illusions. Every student I've ever worked with has been time poor, so I'm also intending to let you have some mini lectures focusing on particular issues that arise in different parts of the syllabus. It's very important in this subject, probably in others too, but this is the one I know about, not just to memorize rules. You're past that stage in your studies now. Of course you need to know the basics, but you also need to know how to apply those basics to issues, whether problems or questions in the exam, in a lawyerly fashion. When the examiner says critically discuss something, you need to demonstrate your knowledge of the subject that the examiner is asking about, but you also need to be able to discuss it. Year after year, the examiner bemoans the fact that students have simply regurgitated what they knew about the rules and said nothing critical. I did once have a student who was very polite and said that she thought it was rude to be critical, and while that's a very nice attitude, it's not going to help with the exam. So you need to be prepared to tell the examiner what's good and what's bad in the law. There's a lot about intellectual property law that can be criticised, and if you read the textbooks and read the articles that you're directed to, you will pick up some of those opinions. That's going to give you the basis for a critical discussion of things when the examination comes around. And of course you can critically discuss something by telling the examiner that you've read what, for example, Professor Bentley had to say about it. Or if you've been reading your cases diligently, then you'll find plenty of critical comments about the law in the judgments of Mr. Justice, later Lord Justice Jacob, and Mr. Justice Laddie in particular, but other intellectual property judges who I expect you will come to know in quite some detail, because there aren't very many of them, and you're having to read a lot of their judgments, have also got a lot of critical things to say. Intellectual property is a relatively new undergraduate subject. At least that's what the module guide tells you. It certainly wasn't on the syllabus when I was an undergraduate, and my first experience of it was as a module on my master's degree. That, incidentally, happily coincided with the publication of the first edition of Professor Cornish's textbook, which I was able to get hold of and read and learn enough from to do the exam. It was a much thinner book in those days. It's now over 1,000 pages, although Amazon a little while ago were listing it at 1,000,000 pages, I think, which seemed a bit excessive. And other textbooks are also pretty substantial. I'll say some more about them later. But I think telling you in 2019 that intellectual property is a relatively new subject and has only started to be taught to undergraduates in the 1980s is a rather strange attitude to the passage of time. It's really a pretty well established subject now, and universities all over the place teach it. However, it's worth mentioning that sometime actually in the late 1970s, I think, the expression intellectual property was very rarely used. Of course, people talked about patents and trademarks and copyright and designs, but they didn't lump them all together under a single heading quite so often. If catch-all terms were used, it was much more likely to be industrial property, which is the expression that appears in the title of the most important and longest established international convention in this area, which is the Paris Convention. You'll be hearing more about that later. And the important point about the expression industrial property is that it was really coined at a time when copyright had no industrial application. So industrial property means patents, trademarks and designs. Those distinctions have broken down in the interim, and copyright is now firmly established as an important industrial property right, but it's been much more convenient to recast these rights as intellectual property rights. Although, having said that, for reasons that you'll become familiar with, that's rather hard to apply to trademarks. The module guide tells you that this is an area of law which is still largely practitioner driven, which in some ways is a rather strange thing to say, because the practice of law is what it's all about. Ultimately, law is a practical subject. But I think in the intellectual property field, it's significant that practice and academia are, I think, closer together than they are in any other area of law. Practitioners lecture, academics practice. There are specialist practitioner textbooks, but the textbooks that you'll be learning from are also regularly used by practitioners. And I think that closeness between academia and practice is one of the things that makes it such an interesting subject. There's no doubt that it's a challenging subject, although in their own ways every area of law is challenging. But there are a few things about intellectual property which perhaps make it challenging in particular ways. And the first point to make is that because the expression intellectual property had no established meaning until sometime in the late 1970s, the way in which that expression is used now kind of hides the fact that that what we're actually talking about here is a bunch of different areas of law. In many ways they're unrelated. They probably have much less in common than they have in common. Than they have not in common. So calling all this stuff intellectual property gives a false impression of unity, and it gives a false impression actually that that if somebody creates something, the law is going to protect it. Whereas the situation is that if somebody creates something, then provided that the patent law or trademark law or copyright law or whatever gives the appropriate form of protection, then it'll be protected. But just because it's an intellectual creation doesn't mean to say the law is going to come to your aid. Practitioners spend a lot of their time exploiting the differences between different types of intellectual property, engineering the most effective and long-lasting sort of protection that the law will give to whatever their clients want to protect, and recognizing that while these are all different rights, they can be made to work together. You don't need to worry too much about that at this stage, because the examiner will ask you about one intellectual property right at a time. It would be very interesting to explore the overlaps between them, but realistically a one-year course is not the place to do that, and you won't find the examiner rolling different forms of intellectual property together in the same question. except in the field of designs where there are several different pieces of legislation that can be engaged at the same time, and it's also possible that questions about confidential information and copyright can overlap. It does mean when you come to the examination you need to look very carefully to see what you're being asked about, because it's not always entirely obvious. Sometimes, for example, in a problem question the examiner will specifically say advise somebody or other about their rights under the Copyright Designs and Patents Act, which gives you a very good steer about what you can earn marks for writing about and what you won't earn marks for writing about. So the next chapter of the module guide and my next lecture will deal more with the different types of intellectual property. So at the moment we'll just note the fact that the topic includes patents, trademarks, copyright and designs. The syllabus includes confidential information or the action for breach of confidence, depending on whether you look at it as the subject matter or the legal mechanism, which strictly speaking isn't really a form of intellectual property, but it's so closely related that you can't ignore it. Some of these areas of law are statutory, others are based on common law, and of course in either case the case law is very important. The oldest statute you'll have to deal with is the Patents Act 1977, the Copyright Designs and Patents Act dated from 1988, and the Trademarks Act from 1994. None of those, you'll have noticed, can really be described as very new, but none of them is currently in force in exactly the form in which it was originally passed, and really they've been amended almost beyond recognition during their lifetimes. You will have a statute book. You must have a statute book. You can take that into the exam and you must know your way around it, but that's a point that I'm going to come back to and stress a little later and probably many more times over the course of these lectures. The law on breach of confidence is entirely judge-made, so you've got to read the cases to understand that, and the same applies to the law of passing off, which is best described at this stage as a sort of precursor to registered trademark law, allowing traders to protect their reputation and goodwill when a competitor tried to take an unfair advantage of it. Another important distinction in the intellectual property world is that some of these rights require registration, or perhaps more strictly speaking they require a grant of something. So patents are granted, trademarks are registered. There's a registered design system as well, which you don't need to know about because it rather artificially falls outside the syllabus. Copyright and design right, which in fact is often referred to as unregistered design right, but that's not the official name, don't require registration. They're automatic, and because they're automatic they deliberately don't give such extensive rights as the registered rights do. Each of these rights, not surprisingly, has its own set of rules about what's protected, for how long, who owns the rights, what it controls, and what's outside the control of the owner. Since the different types of intellectual property are all doing different jobs, it's not surprising that you've got a complete set of rules to learn each time when you come to a new one. The next thing that's challenging about intellectual property is the intellectual challenge that it poses. There's a lot of stuff here and a lot of detail that you have to master. The module guide specifically mentions the detail that you find in UK copyright law, and it compares our law with that of the United States. US copyright law has a single provision saying fair use of another person's copyright work is okay, whereas we have 50 plus sections in the Copyright Designs and Patents Act telling us what sort of acts will be permitted without getting consent from the copyright owner, some of which are on the basis of fair dealing, but fair dealing and fair use are significantly different concepts. So that's a bit of a challenge. There are different ways in which designs can be protected. Mercifully, you don't need to know about all of them because the examiner has taken the view that registered designs can be left outside the syllabus. There is a description of them. You need to know them in background for background purposes only, but they won't feature in the exam. At least they once did, and there was quite a controversy about it, and it was definitely a mistake. But even taking registered designs out of the equation, you've still got the possibility of protecting a design by copyright or by design right, and there's an overlap between the two. So choosing the right way to protect the design can be quite a challenge. Trademark law differs from other areas of intellectual property in that we're not talking about anything which is innovative or creative here, but we're talking about signs that the customer recognizes as identifying a business that they may or may not want to do business with. So the protection that's given by trademark law turns very much upon the power of these signs which are used in commerce. That requires a very different intellectual approach. Patent law can look as if it's going to cause all kinds of intellectual problems, because the subject matter of patent protection is so often very, very complicated. Inventions, by definition, are dreamt up by extremely clever people, and a lot of the very recent cases in the patents field involve biotechnology inventions or inventions in the field of mobile telecommunications, which are pretty well impossible to understand unless you've been educated in that area. And incidentally, patent attorneys who write and prosecute patent applications on behalf of clients have to have a STEM degree, science, technology, engineering or maths, as their starting point, and then they do the legal part of their qualification later. And the barristers who practice in the courts arguing patent cases and who in due course become the patent judges also start with STEM degrees, not absolutely always, but usually they do, so they can understand what the clients are talking to them about. The good news for you is that to understand patent law, certainly for the purposes of this course, you don't need to get yourself involved in biotechnology or telecommunications or anything like that. The law itself, actually in patent law is probably the easiest area of law in the intellectual property field. There's probably less of it, and it has fewer peculiarities, as it all seems to run fairly logically. So you don't need to get freaked out about the subject matter of the cases that you might have to look at. You can probably skip over the technical stuff and just get straight to the law if you're reading a judgment. A lot of students, time-poor students, when it comes to breach of confidence and passing off, the challenge there is to digest large volumes of case law, because there are no statutes to codify the rules. And one thing you'll find is that for any proposition on which you're looking for an answer in those areas, say for example, in order to be able to take an action for passing off, do you have to have done business in the UK, or is some sort of reputation that you've created abroad that people in the UK know about sufficient to found an action? Well, you'll find cases which seem to support both conclusions, that you do have to have a reputation in the UK or goodwill in the UK, and you don't have to have goodwill in the UK. Some sort of spillover reputation will do. And that's very confusing. You can differentiate the cases a bit on the facts, but still you're left with the conclusion that one court has decided the case one way and another court has decided the case the other way. And I think the conclusion is, and it's not a conclusion that you reach only in relation to intellectual property law, it probably applies elsewhere too, but it looks very much as if the way that a case is determined will sometimes, to some extent, depend on how well the parties have prepared their case, how good their barrister was in court, even possibly how well disposed the judge was towards one party or one party's barrister, and whether the judge got out of bed on the wrong side on the particular morning. Well, judges are very careful to be neutral in matters like this, not to have the slightest degree of bias. But that said, they're also human beings, and they must be expected to have some sort of preferences. So perhaps, just occasionally and just very slightly, these come through in the cases. The fact is that you're going to have to grapple with cases which look as if they go in opposite directions. And in both those areas of law, breach of confidence and passing off, there are vast numbers of cases. Of course, there are lots of first instance cases that don't count for such a lot in the doctrine of precedent, but there are cases of appellate courts and more than enough cases from the Supreme Court of the House of Lords. And finally, to give you an intellectual challenge, you've got to take into account European Union law and international conventions. Intellectual property would be worthless if it only worked in the UK, and there are various international conventions which we'll talk about in a future lecture, which ensure that intellectual property rights owners get protection where they need it throughout the world. European Union law has more and more occupied the intellectual property field over the last few decades. In many ways, what's going to happen with EU law is, at the time of recording this, about as uncertain as you can possibly get. By the time we get to the 31st of October 2019, there might be a bit more clarity about it. But EU law has shaped many bits of intellectual property law. The Trademarks Act is based on an EU directive. Copyright legislation is based on several EU directives. Patent law, although it's not based on an EU directive, nevertheless is influenced by at least one EU directive on biotechnology inventions. And decisions of the Court of Justice, and particularly in the copyright and trademarks fields, are enormously important. That's not going to change whatever happens on the 31st of October. And I think it's highly unlikely that the UK is going to stop ensuring that its intellectual property law looks pretty much like EU intellectual property laws. The Trademarks Directive has influenced trademark laws all around the world, even when there's no reason to follow the model of the EU directive, because it's an up-to-date, well-thought-out model. Other countries, including Australia and Pakistan and India and Russia, all have laws that look pretty much like ours because of the influence of the directive. And I don't think the UK is going to have the time, even if it has the inclination, to reinvent trademark law and move very far away from what the EU has been doing for the last 20 or so years. Nor is copyright law going to change very much. And in the patents field, we have to look at the European Patent Convention, which is not an EU measure at all. We're still going to be parties to that, and it fundamentally shapes UK patent law. So we're still going to be faced with the challenge of interpreting UK intellectual property legislation in the context of EU and international instruments. And that brings us to the final thing that's challenging about intellectual property law, which is the pace of change. I think probably more than any other area of law, intellectual property has got to keep pace with external developments. Patent and copyright law have got to keep up to date with changes in technology. What's happened in the biotechnology field has caused problems for patent protection. Developments in computer software have had ramifications not only for patents but also for copyright. Digital technology has been a huge challenge to traditional notions about what copyright should do. Cultural developments also have a massive effect on copyright law, and one of the really controversial areas in intellectual property law at the moment, which doesn't have much of an impact on what you have to study, concerns traditional knowledge and cultural appropriation. The intellectual property world is just beginning to wake up to the issues around these two topics. Well, 20 or perhaps even 10 years ago, we didn't engage with intellectual property to anything like the same extent as we do now. We watched programs on television, sometimes we recorded them so we could watch them later, which wasn't a big issue because the copyright legislation dealt with that. If you copied music from an LP onto a tape, then you had a very inferior recording of it, which you'd probably want to replace as soon as you could afford to buy the LP. Digital technology has changed all that. We stream things, we download them, we rip copies of music from CDs if we still bother with CDs rather than just having the music in immaterial form. the fact that our music collections don't now sit in a cupboard in the sitting room on LPs or CDs, but in the cloud, raises a whole load of other issues as well. Do we actually own anything? Can we pass our music collections on to other people? And our rights are now governed not by possession of the physical carriers, but by agreements that we enter into with the likes of Apple. All of it based on intellectual property. On top of that, the use of trademarks, branding, has become a much more complex activity, and all kinds of complicated issues have arisen involving the duration of patent protection for pharmaceuticals, for example, and access to generic alternatives, and the use of design laws to control the market for spare parts, as well as the market for the complex products that the spare parts go into. If you read the newspapers, you'll find intellectual property in the newspapers almost every day, and you'll soon come to recognise that it's not usually dealt with very accurately either, and that reporters seem to be incapable of differentiating between patents and copyright and trademarks. But even so, there's a lot of interesting stuff there. Lots of prospective exam questions. Intellectual property is also a booming area for litigation. Most parts of the court system have had a very quiet time in the last few years, but not the intellectual property courts. And it's not only sort of day-to-day cases where disputes are being resolved, it's cases where law is being made, where you really have to know about the cases because the judgments make a difference to what you're going to have to write in the exam, and you need to know the law as it stands in the middle of February before the exam. There's a very strong chance that the Supreme Court will come up with something that makes a difference to what you need to know. So as a starting point, you've got to make sure you've got an up-to-date textbook, and you've got to read it. The textbook standing on your shelf is no help at all. The module guide directs your reading in the textbook, whichever of the textbooks you choose to use, and it really is important that you do a lot of that reading. The module guide will give you the very basics that you need to get through the exam, but you'll notice that in many places it's merely pointing you to further into sources where you'll get more information, or it's setting you thinking about questions that you then have to go and find the answer to. So it's by no means complete, and a textbook is very important. Which of the textbooks do you want to should you be using? Well, that's very much a matter of personal taste. Cornish's book and Bentley and Sherman are bigger than the others. Bainbridge, I'd say, is good on technical issues, computer software and things like that, because that's the author's background. Helen Norman's book has the advantage that it's quite closely related to the module guide and to the syllabus, and of course she's one of the co-authors. She was the only author until recently of the module guide, so it's not entirely surprising that there's a close relationship between the two. Cornish is rather heavy going, but I think probably the most intellectually rigorous of the books. Bentley and Sherman is very detailed. It has the advantage of illustrations, which I think you'll also find in Bainbridge. Not exactly the same ones necessarily, but illustrations certainly help with understanding some of the issues. Have a look at them all and decide which one you can relate to most easily. If you can manage more than one, so much the better, but I think it's unrealistic to expect any student to deal with more than one at a time. And incidentally, Bainbridge I think is available in the VLE online, so if that book suits you, and there's no reason why it shouldn't, then you might be able to get by without buying a book at all. You won't get by without reading a book, you won't get by without reading judgments, which you can find on the Bailey website quite easily. You might even want to look occasionally and see what the latest judgments are of the Patents Court and the Intellectual Property Enterprise Court, which are the most important courts for your purposes. Sometimes there'll be a copyright case perhaps in the Chancery Division, and of course there'll be cases in the Court of Appeal and the Supreme Court. The University of London will produce an update in February stating what the law is that you need to know for the exam, so you'll get any important developments brought to your attention later. But if you want to keep up with things as they develop, well, I've got my blog which I try to keep up to date, but you should also have a look at the IPCAT, or IPCAT, cat with a K, .com, which was originally launched for the benefit of people like you, students studying intellectual property law. It's developed a long way in the years since then, and it will tell you an awful lot of stuff that you don't need to know for the exam. But there could be a lot of stuff there that you do need to know for it, and it's well worth keeping an eye on it. So those are the challenges you're going to face studying this subject. I hope this hasn't done anything to put you off. Ultimately, the important thing is how you do in the exam, and to prepare for the exam you'll find useful sample questions included in the module guide, so you can have some practice at writing answers and get a feel for what the exams are like. You can find recent exams, well, you can find all the exams I think on the VLE. There's no point in looking back earlier than 2015 because there was a big change. There was a change in examiner then, and earlier exams are no longer typical. Obviously, looking at earlier examination questions can still serve some purpose, but you might as well look at the more recent ones, which are more typical of what you're going to find in your exam. Look also at the examiner's reports that are published on the VLE, so they give you some very useful hints about how to write answers and what the examiner is going to be looking for. I've recorded a number of mini lectures which are on my YouTube channel explaining how to go about answering a question, or at least how I think you should go about answering a question. Since I neither set the exams nor mark them, I can't be entirely sure, but there are certainly techniques that you should be aware of to answering the sort of questions that come up in the intellectual property exam. And when I have time, I'll record some more mini lectures and put them on YouTube channel as well. So do please subscribe to that. You can take the statutes book into the exam, and that's going to give you a lot of the stuff that you need to use to answer the questions, and it's also going to help you provide a framework for your answers. But if you don't know your way around it before you get into the examination hall, it's going to be useless. In fact, it's going to be a burden. So make sure that you learn what the structure of the legislation is that you need to know, so that you can find your way very quickly to the section that you need. So you're going to find intellectual property a challenging subject to study, I'm sure, but it's also very rewarding. And not only that, it's also very relevant for the reasons that I explained. It's very closely related to what we do day to day in so many ways these days. So it's nearly 40 years now since I first started doing anything in the intellectual property field, and I always count myself very lucky to have found my way into intellectual property rather than some other area of law. It's been very, very interesting, very enjoyable, and I'm sure you're going to find the same. Thank you very much for listening. I hope you found this useful, and I hope you'll find future recordings useful as well.